But anyway, let's go on to the amended complaint and read it and go through it. And then, so now we're gonna go on to the second amended complaint. It is 55 pages long. I'm gonna do my best to try and condense this down so that it's not too long for you guys. But I will skip over some bits that I think it may not be all that relevant, like the nature of action or the parties, all of that. I'm not gonna go through all of this, but I do think there is a lot here that will pique your interest. I will give a little bit of a preview here and say, after this complaint was filed, it is now received that Taylor Lorenz and New York Times has actually petitioned in for, I believe it was a 3-day extension to respond to this complaint. And it writes itself, doesn't it? Because in my honest opinion, if your case was really that strong, this shouldn't need an extension to per se. Maybe I'll give it the benefit of the doubt, though. Maybe they are looking for evidence to counter this, to say, look, this is really frivolous. But just from that alone, it doesn't seem like this is, in their favor in any way at all. So I'm gonna go into the complaint to show you what I mean. So we know about the choice of venue. We know about the the background of the plaintiffs and the allegations that was already caused in terms of the hit piece, etc. I would love to go through all of that, but I am going to link the complaint onto here, onto the description of the video, so that you guys can go read it for yourself. But it's just giving an outline based on what happened, and there is a bit of evidence here. They have given, I guess I'm gonna have to go through it now because I think they are all tied in. So I'm gonna start with defendants publish the article. So I'll say, okay, so I'm gonna start here. So it says defendants published the article on August 14th, 2020, just 4 days after Lorenz first contacted Jacob. The article was titled "Trying to Make It Big Online, Getting Signage and Everything," and the subheadline read, "Young people come to Los Angeles in droves with dreams of fame and fortune. Once they're discovered, it's not always sunny." Despite purporting to be about the influencer industry more generally, the article was nothing more than a hit piece about Jacob and influencers. Immediately below the headline is a picture of Jacob and some of the influencers she represented. The caption to the photo identifies both Jacob and influencers and says that they turn their client's dream into a living nightmare. This was the quote earlier that was a matter of opinion and not really actionable. This sets the tone and provides the context for defamatory assertions and impressions that the article goes on to make. Many of the false statements in the article involve the intentional misuse of industry's terms to suggest a malicious motive on the part of plaintiffs. For example, defendants quote one of the plaintiff's former clients, Marcus Olin, who lived in the Kiss Next Door K&D influencer house that plaintiffs managed, as claiming that he was misled by the plaintiffs into believing that plaintiffs would provide a guaranteed quota of brand deals that would generate sufficient revenue for the K&D influencers to cover their share of the rent. Now, I think this was dismissed, but if you are allowed to bring back statements that were dismissed and provide substance to it to be considered here, I'm not sure if you are. I'm really not sure here, but if you are, then power to them. But I felt like this, once it's dismissed, it's dismissed. The judge is not gonna consider that based on what I read in the previous complaint. So again, I could be wrong, but I just thought it's interesting that they're bringing this back. Maybe they're not. Maybe they're just giving an overview of what happened. But anyway, let me see. This was false. In truth, the K&D influencers had signed a production agreement that required them to post a certain number of social media posts, not brand deals, and pay their share of the rent. As defendants well knew, production agreements of this type are common in the entertainment industry, as they enable an aspiring influencer to live in a mansion in the Hollywood Hills in exchange for A, contributing to rent, and B, posting to on their social media accounts for the mutual benefit of the collaboration house and themselves. By stark contrast, brand deals are when a company pays a creator to advertise its product, thereby generating income for the creator. Lorenz is deeply familiar with the influencer industry. She's even the author of a book devoted to the subject entitled Extremely Online Gen Z: The Rise of Influencers and Creation of the New American Dream. Given her industry expertise, Lorenz knew that a social media post is different than a brand deal post. Moreover, Jacob, through her attorney, had put Lorenz on notice pre-publication of the existence and nature of their industry standard production agreement with the influencers. Despite this, the defendants falsely stated that plaintiffs had guaranteed brand deals sufficient to pay the influencers' rent. In addition, the article quotes Olin further as claiming that the K&D influencers were not getting enough brand deals to cover their half of the rent. This is also false, and the other K&D influencers were in fact getting substantial brand deals at the time, as Lorenz and the Times would have easily discovered had they bothered to check their sources social media pages. I love it when you read complaints like this, and it's so formal and it just goes off the cuff for a minute and used. It's just funny because I wouldn't expect had they bothered, to be part of it. It's like, something like, I would have thought something like, should they have checked their sources, they would have known, or something very formal, but to say bothered is anyway. I'm making a big deal out of it. Don't mind me. Indeed, it is apparent for Olin's Instagram and TikTok accounts that he had over 20 brand deals between May and August 2020, as but a few examples. It's also important to note here that losing this business on the cusp of COVID is very cruel. Like, it is cruel because we all know that the global shutdown, this is internet based. I understand. That's not my point. My point is losing a business in a global economical crunch, not necessarily the same financial crisis of 2008, but this one is when everything was being halted and no businesses could perform. It didn't impact online businesses too much, but there was an impact that if you were out of that market, you'd be forgotten kind of impact, especially when everyone was relying online. It would have been a really big boost for them, and if they weren't in the forefront of this and they lost their business, it would have been very hard to recover because there were so many brands at that time trying to push out content so that they can capitalize on the extra attention that was available. Believe me, like, if you lose your business at this point, no matter what you're doing, it's going to be stupidly difficult to claw back whatever you've lost. So I can sympathize with Taylor Lorenz, what am I saying? With Ariadna Jacob here, because in that time, losing your business, it's just cruel to me. This is one of the brand deals that they're posting on social media. In this case was Instagram, and also TikTok on that side to also post the brand deal there. Another post here. So these examples shows that there has been a contract and they were acting on it to show this collaboration. Indeed, at the time Olin posted these brand deals, he had over 10 million followers, and his posts were getting more than 20 million impressions each. In the summer of 2020, several of the K&D creators had engagements similar to that of celebrities who made more than 75,000 per post. Defendants could have easily confirmed this fact. And the reason why I do believe that Taylor Lorenz just didn't care is because, one, she wanted to get ahead and also have eyes on her. At the same time, like I said, going through that era of COVID, honestly, if you had any business, like I had a physical business that was me as a DJ, so the clubs were shut. I had to try and restructure to online. And yeah, because I didn't have an online presence, I couldn't get in. But the people that were already, online and were already doing their thing, they were basically the market leaders for this. And so many businesses at the same time were, pulling their weight that were online as well. So that's the point I'm trying to make here. Like, her doing this, there is not just there is a motive behind it, which was she needed this piece to really hit so that she can get clicks and she can boost our profile for discovering all this. And I'm not gonna try and link it to how she reacts with the whole long COVID thing and having a I'm not gonna link it to that, but the main point is the way that she has positioned herself to be very concerned about this whole COVID thing and doing all of this and trying to expose Ari Jacobs is playing on the inference that there is a lot of attention on TikTokers and social media influencers, and this person, Ari Jacobs, is trying to take advantage of that by giving them frivolous deals. Many people may not see it like that, but from someone who has been in the industry, that's exactly how I saw it. That's exactly how I'm seeing it, reading all of this, because it just seems very clear to me that this is nothing more than to make herself look good by trashing somebody else. That's all it is. And it's just taking advantage of a situation that was unfortunate for everyone involved. And I'm not sure how many people made that connection. Probably a lot of people did. I'm probably speaking to what everyone is saying, but it's just so apparent to me that it just can't be ignored, because Taylor Lorenz, is very, very performative from what I've seen of her posts and herself. So I just thought I'd put it out there. All right. So Lorenz's 35. Lorenz's failure to check Olin's and the other influencers' social media pages in order to verify the claim of not having enough brand deals to pay rent further evinces a reckless disregard for the truth of our publication. Since Lorenz claimed to keep a meticulous daily record of every post she sees on every platform and finds this practice extremely useful in reporting, it is obvious that she failed to fact-check this claim in her article. Moreover, given her familiarity with the industry, Lorenz also knew that influencers have several different revenue streams, including TikTok, live streaming, YouTube advertising revenue, and selling merchandise. Influencers are known to make thousands of dollars through gifts that are sent to them on TikTok live streams. Olin, Underhill, and others live stream daily. This makes sense because this was the online presence at the time. And the gifts they received were public for anyone to see. Lorenz would have only had to watch one of these live streams to see that the candy influencers were generating significant income from their live streams. Her failure to do so was a reckless disregard of her duty to adequately fact-check the article before stating that the influencers lacked the means to pay the rent, and implying that plaintiffs were therefore taking advantage of them. Now, I get this argument, I really do, because when it's kind of like that, argument. It's not the same, but it's kind of like that argument with Amber Heard, where she posted on her Twitter, "Today I published this op-ed." So because of that, she took ownership of the title. Therefore, it became her title, or she even though she didn't write it, she basically accepted responsibility for it, so to speak. It's not the same exact thing, but the point I'm trying to make is, even though that is not required as a journalist per se to meticulously and daily look on live streams and do all of this, even though that's the case, I see what they're arguing in terms of, she said it, so she gave that standard to herself, and she didn't even live up to that in an adequate manner, or at an acceptable level, from what I'm gathering, from what I'm reading here. I think it is a good argument in my honest opinion, but I think it will be, I mean, whether the court would go for it, I have no idea, but it'd be kind of unfair to use an opinion, because I don't think it's factual that she has to hold herself to that standard, but to use that opinion in a sense to say, because you said this, therefore you must have gone through it, it's a bit harsh to me, because you can't be punished that harshly just for putting it out there. But it does speak to the idea that she would say these things to boost her credibility, and to give that kind of insight to her, the way she researches, and give the impression that she's really after the truth. It does give that impression, but when you look at it, and give that impression that she's really after the truth, but when you look at it like the way they are, she hasn't even done that, because this is an example of that. So it makes sense why they would argue it like this. Whether the judge will go for it or not, I personally think if the judge was to rule on this, I wouldn't be surprised if he says that this is not necessarily the standard for journalists, and it would be unfair to hold her to this in terms of actual malice. But again, I do think you made a statement, you put it out there that you are making, that your claims are factual, that everything that you write is factual, and yet you haven't even done a basic search to see this is, that this is easily refutable. So it does have that other side as well. I'm just pointing that out. Number 37. Defendants then quoted Jesse Underhill and another member of the K&D house as falsely claiming that the K&D influencers were without Wi-Fi for a month, which prevented them from going live with the influencer content. Remember, I said this earlier in the previous complaint, that they were using a suspended account, so they couldn't necessarily go live because they were suspended. How could they? Anyway, this is false, as defendants knew, or should have known indeed, when the Times came to the K&D house in May 2020, shortly after the K&D residents moved in preparation for the piece they published later that month on the state of TikTok collaboration houses during the COVID-19 pandemic. This is what I was talking about. They were able to connect to the Wi-Fi. Defendants displayed reckless disregard for the truth of these no Wi-Fi statements by intentionally failing to ask plaintiffs about this issue prior to the publication of an article, and failing to ask her employer, The Times, about this issue, which would have easily proven her statement false. That's a footnote which goes on to explain the collabs. I'm going to go into that. Number 38. Defendants then claim that at the end of July 2020, plaintiffs informed the K&D influencers that they would have to cover a larger share of the rent. This was false. The contractual rent owed by the influencers never changed. notwithstanding that the influencers routinely flouted the terms of production agreements and generally took advantage of plaintiffs' grace and leniency, and plaintiffs correct defendants on this point on 3 separate occasions pre-publication, yet defendants recklessly published this statement to further their preconceived narrative and then double down on it with tweets that further labeled plaintiffs as quote-unquote bad actors, which took advantage of young professionals as seen here. I wrote this piece recently, which gets into it as this phenomenon spreads and more kids want to be part of these. Bad actors are entering to take advantage of the situation. Like I said, it's the influence. Like, you know what I mean? She's literally playing on the fact that there's a big boom in TikTok at the time. Not just that, there's a lot of online activity based on everyone going into lockdown. So she's really playing on it hard by tweeting this to whoever Sarah Kelly is. I don't know who that is, but she's not hiding it. It's basically the point. And she knew it was false when she was doing this. Again, actual malice inferred. They didn't have to do this, in all fairness. They didn't really have to go this far, but to me, just by reading this alone, there's enough that should have this claim survive the anti-slap motion here, brought by the defendants. Okay, number 39. The article then included a section heading entitled "Have you made any money?" and quoted plaintiff's former client, Brittany Tomlinson, as stating that Jacob had asked her, "Have you made any money?" After one of Tomlinson's videos went viral. Number 40. One of the defendant's preconceived goals in writing the article was to paint plaintiffs as liars, including about their professional affiliations. To this end, they deceptively juxtaposed 2 facts. First, quoting Tomlinson as saying that Jacob told her she had been mentored by an entrepreneur Gary Vaynerchuk, and then stating in the same paragraph that Mr. Vaynerchuk said he has no affiliation with influencers. Defendant's juxtaposition gave the impression that Jacob had misrepresented her relationship with Vaynerchuk, but the truth, which defendants knew and which they could have easily confirmed by review of public sources, is that Vaynerchuk had mentored Jacob and held Jacob in extremely high regard, which is why I showed you the video earlier. This is what they're talking about. But a few examples from the public record, influencers posted a video on YouTube entitled "Meeting My Hero," proving that Vaynerchuk and Jacob friendship began in 2009. Did not know that part. I did not know that part. That's damning, in my opinion. Like, I mean, that's okay. You can argue affiliation between the brand and influences and Vaynerchuk Media. You can argue that they don't actually have affiliation, but that doesn't mean they don't have friendship. That Gary Vaynerchuk would do favors for Ari Jacobs outside of Vaynerchuk Media and influencers, which are separate entities from these two. They own the company, but they're still separate entities. It doesn't mean they just don't know each other just because there is no link or affiliation between the two companies. Like, this is what I was talking about earlier. Like look, reading the article, I can see the obvious inference that that they're trying to play on people's ignorance of not knowing the difference between a company and an individual person. So this is damning, in my honest opinion, that such provable information was available out there and she didn't go to check. Did she have to? Not really, but she could have inquired from Ari Jacobs herself and asked, "Look, are you two friends or not?" You know what I mean? But she didn't care. She just wanted to create a narrative sort of thing. B. Another video which was live streamed publicly to the influencer's Instagram page in the summer of 2020 shows Vaynerchuk and his business partner Ryan Harwood introducing themselves to the group. In the video, Harwood says, Gary and I have both known Ari for a very, very long time. We are huge fans of everything that she is up to out there. And just her, what's the SIC? Sick as a human? As a human being? I don't know. I don't know. I don't know what sick means. But this is, again, damning. I played that video earlier. And you can go watch that video to see the whole conversation. But again, this is out there. It's public information, and not just public information. It's information that you could have just messaged Jacobs and just find out. Look, what is the deal with you and Gary Vaynerchuk? Is he your mentor or not? Because she's saying that he's not your mentor. Again, it's not something that if you didn't have to reach out to Jacobs, which I presume you're supposed to, but if that wasn't a requirement and you're supposed to question your sources, you could ask, why do you think, Gary V is not, the mentor? It should have enough to make you go and do your own investigation if you're going to report this as fact. It's what this is trying to infer. So again, actual malice, the influence here is a lot that it should survive the motion. Let us see. In fact, Vaynerchuk respected Jacob so much that he eventually offered Tomlinson a spot on a Super Bowl commercial expressly because of Tomlinson's relationship with his friend and protege, Jacob. This is very interesting. The video that I saw wasn't actually public until now. It's unlisted. It's labeled as unlisted, so it was private before, but she may have just uploaded it just to prove that this actually happened. And having such a record, I don't think she was recording it for this purpose. I just think she was recording it to say, look, Gary V has done this for my client, they can do it for you too, kind of thing. It was from what I'm understanding, it was a brand boosting type of video to invite further clients to say, look, I can do this for you guys if you join in. That's what I'm understanding from all this. I don't think she did it just for this video. Just for this case. It'll be very impossible to preempt what Taylor Lorenz is gonna do, but the way it has turned around to help her case a lot is showing that there is a lot here that we're not knowing. Especially, why would Tomlinson throw Ari Jacobs under the bus like this? I am very interested to see the defendant's rebuttal to this, because for Tomlinson to do this to Ari Jacobs, knowing this and knowing it damn well that there is a relationship, because in the video, like I played a few of those clips, in the video, she gives credit to Ari.
I wasn't expecting him to go all out, but yeah.
I wasn't expecting him to be like saying so many nice things. That made my day. That was
he was
crazy.
he was big on you as well. He was like,
Ari, this is all you.
Dude.
He said, I'll be honest, this is a favor to Ari. She's my homegirl.
Yeah, right. No, he just said that because he knows that makes me happy. But, you're a star, Brittany.
you made him happy as well with the whole copywriter thing.
I can't even imagine that someone would try to negotiate with him like that.
So, I don't understand what would make her believe that there is nothing here, and Ari Jacobs was trying to give a false narrative that Vaynerchuk was her mentor. I mean, you have it right there. I'm baffled. I'm really baffled. Without knowing much about this, I'm looking at it and I'm like, Tomlinson, what's actually going on with you? There's something in the water. Lorenz was aware of these facts prior to publishing the article, yet chose to ignore them in yet another instance of reckless disregard for the truth. And in sourcing the article, Lorenz purposely manufactured an apparent inconsistency between mentorship by Vaynerchuk of Jacob and affiliation between Vaynerchuk and influences. Defendants then deceptively purported to answer the rhetorical question they had posed as to whether Tomlinson had made any money by falsely suggesting that plaintiffs had been withholding or delaying payment of Tomlinson of tens and thousands of dollars. They quote Tomlinson as stating that January, I realized I hadn't paid since Halloween. Defendants then claimed that Tomlinson reached out to the brands that she had worked with and discovered that she was owed tens and thousands of dollars. These claims are false, as plaintiffs notified defendants pre-publication. First, Influences was not responsible for paying fees to Tomlinson, who was signed to a separate company, Creator Edge, and second, Tomlinson had been paid during the months of November and December, and any delay of the payment stemmed not from plaintiffs but from the general delay that Influencers were suffering in receiving payments from brands at the time. Defendants knew this, both because they had been put on pre-publication notice of falsity by plaintiffs, and because they were aware of general payment delay industry-wide. Again, COVID is a very big proponent of this, and I'll explain in a minute. In fact, Lorenz had offered an article in The Atlantic in November 2018 in which he lamented that delay that influencers suffer in submitting content and receiving payment from brands, yet defendants recklessly ignored these facts to instead create a false and misleading impression about the plaintiff. So the video is there in the footnote, but basically the point is, if I didn't know about the 2018 article that she done, so if that's factual, that brands do delay in paying their influencers. Imagine COVID. Imagine COVID when every one of these, and this is how the COVID impacted the online industry in a unique way. Not that creators were not getting paid or anything like that. It was just a bit harder for creators coming up, in my opinion, to receive these brand deals because they were kind of prioritizing their major players, if that makes sense, so that they can still bring in the revenue and still boost out the products. And it wasn't every brand that was doing this. Like, it was the brands that people cannot live without in the 21st century, like the makeup brands, food, deodorant, all of those things that you would need to function in a daily life. It wasn't really the extra supplemental brands. I can't really think of anything right now. My mind's going blank on that, but you get the impression that I'm trying to give, that it wasn't just every brand putting it out. And if these brands were to reach out to these creators, it wouldn't be at the same rate that they were doing pre-COVID. So that is also important to note. So and not sure if you noticed, there was a lot of uptick in online security brands, all affiliated with a lot of these creators. So there's also that aspect as well. The point I'm making overall is the fact that if these guys were being delayed already, then in COVID it must have been worse, that it wasn't Taylor Lorenz's fault. That it wasn't Ariadna Jacob's fault. I keep saying her name. Come on. Anyway, that it wasn't Ariadna Jacob's fault that all of this were happening. It just needed a little bit of, hey, what actually happened with the brands? Oh, this happened. Okay, perfect. That's the truth. Let's move on. But that didn't happen. She just went ahead and published anyway. Actual malice, there again. And I can't believe how many boom actual malice is being presented here alone. 43 defendants then claim in April 2021 Tomlinson filed a complaint with the California Labor Commission alleging that Jacob had violated Californian law by operating as a talent agency without license. What Lorenz could easily have established but recklessly failed to include in an article was the fact that Jacob did have a talent agency license at the time, and the article was published. And the California law allows individuals and corporations who are not licensed talent agencies to negotiate employment contracts in conjunction with and at the request of a licensed talent agent. Further, Lorenz knew as early as May 2020 that Influences was properly working with a licensed talent agent because Jacob had emailed her with this information on May 14th, 2020. Lorenz's decision to mention Tomlinson's California Labor Commission complaint against Jacob, but not key facts she was aware of that intended to establish that Jacob had fully complied with California labor law in her dealings with Tomlinson, showed reckless disregard for the truth, and committed to her preconceived narrative of Jacob as an unscrupulous business person. That doesn't help. That really doesn't help. It sounds. I don't know if they're gonna bring it back. I'm not sure if they are bringing back all of these statements that were dismissed. I'm not sure if they're arguing for that again. I don't know exactly, but from this complaint, it looks like they're going through all of those statements that were dismissed again. The article then goes on to quote Tiana Singer as stating that plaintiffs had promised brand deals, money opportunities, and that everyone was promised income, but that never happened. Contrary to defendants' misleading implication in the article, Singer was not even managed by plaintiffs. Indeed, plaintiffs chose not to sign her as a client because of her meager social media following. This is too funny. Oh my gosh, you just... Wow, okay. I can see this person hurt Ariadna Jacob a lot. Meager. Wow. Instead, Singer was simply allowed to be the guest of the Girls in the Valley GIV influencer house if she produced content and agreed to the terms of Influences, standard release and non-disclosure agreement. Moreover, the GIV residents who were signed to plaintiffs at the time were aware through their signed agreement. Once again, Jack Daniels time. That plaintiffs had not promised to procure brand deals. I should have waited to actually stop reading to the full stop. Anyway, there's no better time than Jack Daniels time. Anyway, defendants never investigated or asked plaintiffs about these issues prior to publishing the article, instead choosing to carefully parse their words to leave the reader with the false impression that Singer was yet another client who was lied to and disappointed by the plaintiff's quote-unquote promises. Singer's statement that brand deals and opportunities were never materialized is also false, and defendants could have easily confirmed this fact by reviewing the social media accounts of the influencers plaintiffs managed, which boasted about multiple opportunities. Jacob even directly notified Lorenz of one especially big opportunity called Playlist Live, and sent Lorenz detailed information about a trip organized by influencers and sponsored through a brand deal that dozens of influencers and Singer were set to take to the Playlist Creator Conference in Orlando follows. Oh, you're done. I'm sorry, but you're done. It's right there in 4K. It's not like you didn't. Oh wow. This is probably the one case that should not even have anti-slap motion given to it. It did. I'm sorry, but what more proof do you need to say? Let's just. I bet the judge is reading this and was like, "Okay, fuck this. Let's just go ahead with the case," because there's no way. How do you argue? How do you argue against this? I'm sorry, but I mean, are you gonna say next, are you gonna show a text message in there that says, well, this person says this, so therefore, I don't believe what you're writing there, Ari. I mean, at least if you have such a communication, you can actually say, look, it was just a case of whether I believe her or not, because I relied on this person's information, sort of thing. So I didn't know whether it was false or not. Maybe I'm misinterpreting the idea of actual malice. But I believe if there is such a message of saying, look, I'm not saying I don't believe you, I'm just saying this person made this claim and showed me this. I think that would go a long way to help Taylor say, look, listen, this is not actual malice. I didn't know it was false, or did I know the truth of it and just disregarded it? I was just in a position that, I didn't know who to believe. So it's not like I'm going to decide to not write the article, but it's an opinion. Like, I'm just going by what the facts this person showed me versus, the fact that was shown by Ari. If that's an argument, I think if she has something like that, I think it's enough to squash, this inference that she didn't know, for actual malice. But if she doesn't, which I don't think there's enough due diligence here, but we're just reading one side. But I don't think there is even anything here to suggest that she does have such information. From just reading the declarations that I showed you earlier, it doesn't seem that she actually cares for any of this. But I could be persuaded by the complaint that I'm reading here, and I'm a bit biased towards Taylor, but I'm trying my best to actually be objective, because you know me. If you know me on Insta, I don't like her, but I'm looking at it and I'm like, the only thing you can do to save yourself is this. I'm trying to be as objective as possible, but it just doesn't look good that there's verifiable information of this, but yet you just went ahead and printed what you printed anyway, as if you didn't know that these brand deals existed, for example. She could even argue that she didn't even know that this was brand deals, but to me it just seems like there's just a brand deal right there that she's being presented. It's damning. It's just damning. It's just damning. In addition, in Lorenz's May 2020 Delayed Moves article, Lorenz published statements that confirmed that Lorenz was aware of the opportunities available to GIV influencers, which undermines defendants' false statement that such opportunities never materialized. Business as usual, many creators have pushed back their plans in light of the pandemic. The Girls in the Valley, a female-only TikTok house, was on track for a late March move and even held an opening party on March 12th. Makes sense. Pandemic. At the Sugar Factory in Los Angeles, featuring the pop star Doja Cat. That would have been big as well. Now, with their moving date to be determined, the house members have turned to weekly Zoom calls to stay in touch. This is actually what happened a lot with, in my industry, it's not the same as this. It's completely not the same. But they were doing a lot of these podcasts at the time to try and still connect with big DJs, to still try and help their base, to retain their base, basically, to do something that was outside the club scene. I even remember them having collab streams. I was part of one of them, where they had collab streams of DJs giving back-to-back, hits. You know what I mean? Playing like it was fun, but it was kind of a compromise or alternative to the obvious problem that they cannot do these parties or these events that they were planning to do because of everything that was happening at the time. And again, it just seems like she was playing on all of that, and the inferences here is just seems that all of these layers that she was laying was leading up to the article per se. Further, the article alleges that plaintiffs installed a security camera in the kitchen without consent of the GIV house members, an all-girl group, so this is pretty serious. This is patently false. In fact, the GIV house and other collaboration houses managed by the plaintiffs had an iPad at the entrance with a system that required any entrance, whether house members or guests, to sign in and sign a liability release and waiver stating that the house has video surveillance in all rooms other than restrooms and showers as follows. Before I even read this, I already if the Kyle declaration was not enough, I'm surprised she's going this hard, because you must have a really strong case. You must have a really strong case for this. But let me just go and read. I further understand that in order to promote the safety and employees of employees and visitors, as well as the security of the property, that this property has video surveillance inclusive of any bedrooms, the only exception being private areas of restrooms and bedroom and showers. I hereby give my consent to such video surveillance at any time of influencers may choose. I'm not gonna read it anymore. It's obvious, and she signed it. So what are you talking about? What is this? This is what did she hope to gain from this? In all fairness, with this whole article, I can put Taylor Lorenz to one side, but let's look at the creators here that are speaking in the article. What did they hope to actually gain from this? Like, that's what I want to know. I mean, I can blame Taylor Lorenz all day long, but come on. She could easily, I mean, I can see that coming in a complaint that she's gonna, I'm gonna cover that as well, but I'm gonna assume that it's gonna say, look, they gave me this information, I just relied on it, and I felt it was truthful. I did not disregard the truth. I did not know it was a lie. I just felt like the information that these guys gave me was enough. I believe that would be a complaint, but it's so verifiable here that even with that complaint, you're not gonna dismiss this, because, I mean, come on. Anyway, it was well known across the content creator industry that influencers require guests of the content houses to sign agreements of this type. An agreement of this type, sorry. And this was also common practice at other collaboration houses that existed at the time. Defendants were made aware of these facts in pre-publication communications. What's more, Lorenz and the Times, by virtue of their deep knowledge of the industry, knew that security cameras were industry standard in the influencer houses, such as K&D. Indeed, when a photographer from the Times visited the K&D house in May 2020, they asked if they needed to sign in on the iPad, indicating that the Times' knowledge of the industry standard practice. So this is not even just Taylor Lorenz's actual malice. This is also the paper's actual malice. So, Jesus Christ. This is... I'm sorry, but this is bad. Knowledge of falsities. Moreover, evidence of videotaping was visually apparent from the iPad that was installed on the walls of the house. That defendants nonetheless published this baseless accusation shows the extent to which they recklessly disregarded what they knew to be true, our desire to smear plaintiffs. I mean, yeah, that's what it is. I mean, like, they couldn't just pull up and just say, we're not gonna print that part, but we're gonna print everything else, because if something is that easily verifiable, why would you risk your reputation like this? Wow. Absolute wow. All of this simping for Taylor Lorenz? Really? Like, really? Alright. Defendants also misleadingly suggest that Jacob threatened to throw all the GIV girls out of the house unless they posted content at least 8 times a day. This was false, and defendants knew it. First, Singer and the members of the GIV house themselves came up with the posting schedule in June 2020, as they wanted to be on the same schedule as the K&D influencers going forward. This can be seen in the following text by Singer. Oh my. Why? The question is just why? Why do this hit piece? I'm gonna put New York Times to one side. I'm gonna put Taylor Lorenz to one side. They may have fumbled the camera a bit, but come on. Okay, what's the motive of these people of Singer? I actually want to know. Why would she also make these statements and quotes? What's Tomlinson's motive? What's Olin's motive? What's going on? I don't know this. This is very weird to me. That it's this obvious and it's this verifiable, and it's still went ahead and made it. I can put the blame on, again, it's evidence of, Taylor Lorenz, the Times, they're just relying. That's fair. I mean, I can say that they're 100% culpable for the cameras because they were actually there, but this, why? Why is what I want to know. Second, in the light of defendants' extensive knowledge of the influencers industry, they knew that it was perfectly reasonable for plaintiffs to encourage their members to consistently post content on social media every week. And this formula is precisely how collectives such as GIV typically operate. Defendants knew that the value of spending time in a collaboration house is to collaborate with other influencers who are committed to consistent content creation, and that posting regularly on social media is the only way for influencers with small followers to grow. This is obvious. Even I know that. And I didn't even have an online presence, but I know you have to consistently post and have interaction and impressions to actually have traction to your content, not just traction to your content, but also be able to use that traction, use those impressions, use all of those information and data to make an argument or create a business plan to give to prospective brands that you want to be affiliated with your content, or with your TikTok business, for example, or YouTube business, or whatever. Like, this is just business 101. This is required. To suggest that plaintiffs' encouragement of regular posting was oppressive, that demonstrates defendants' dogged determination to create a false impression of plaintiffs. Wait, oppressive? What? Regular posting is oppressive? Why are you in the industry? This is what you do. What? How else are people gonna see your content? I'm sorry, but what? You signed up to influences to grow. I'm just not understanding here. They're gonna help you grow, but if you can't be helped if you nah, man. Anyway, defendants never even asked plaintiffs about this issue before posting the article. I mean, that's okay. Taylor, take the L for that one, because you should have. You don't even need to be in the industry for that. It's just common sense. How do you get your content from 1 view to 1,000? Are you just gonna put it on YouTube and just wait and just hope it just gets 1,000 views? No. You're gonna post it on your Instagram or Twitter. Like, it's just obvious. How do you not follow up on that? I'm sorry. Take the L here. I'm so sorry. I'm sorry. Take the L. Take the L on this one. Moreover, Singer was ultimately asked to leave due to breaking rules such as hosting parties during COVID-19, shelter in place, underage drinking, and becoming a problematic influencer who take advantage of plaintiffs' creator house without generating results. I must say, the old drinking thing between 21 and 18 in the UK, that's not. I mean, I'm looking at this and I'm laughing at underage drinking, because I mean, I was 19 when I was drinking. It was in the UK, so whenever I see this, I'm like, my brain racks a little bit because I'm like, anyway, different country, different laws. I don't care. But the point is, the COVID-19 restrictions were actually in place, so they shouldn't really be breaking these rules. Moreover, it says singer ultimately asked to leave due to breaking rules. Ultimately asked to leave due to breaking rules such as hosting parties during COVID-19 shelter in place, and essentially becoming a problematic influencer who took advantage of plaintiff's creative house without generating results. So, this is motive to lie as brazenly as this, but it's also enough to see why Taylor Lorenz would actually prey on her to write for her article, regardless. So if you want to put it in any simple way, it's double malice. If that even exists, it's double actual malice. She knew, singer knew everything that she was acting was false. Taylor knew that she was a disgruntled former employee, if she even knew that, and she was gonna say anything. Again, more onus on Taylor Lorenz to do her due diligence on this, but she hasn't. Defendants then said the claim that GIV girls got into escalating verbal fight that Jacob that resulted in several calls to local authorities to intervene. This statement, when juxtaposed with defendants' statements that GIV girls were intimidated by explosive conversations with Jacob, creates a clear impression that Jacob's aggression and intimidation caused the GIV girls to call the police. This is a lie, and defendants knew it. This is because prior to publication of the article, defendants were informed that it was Jacob who called the police and on the girls twice because of their threatening and aggressive behavior. Defendants were also informed of their farewell vandalism the GIV girls performed days before their move-out dates, which also prompted Jacob's calls to the police as shown by the following documents. Oh, wow. So, imagine this doesn't exist. Let me just hide the email before going to it. But look at this. This was in the article. This email gives the context. Okay, so it says, if Miss Jacob wasn't the leaseholder of the girls in the Valley House, how did she have the power to kick and lock the girls of the house? We did not kick them out of the house and lock the door and have witness to verify. We asked them to vacate over the next couple of days since they were never formally invited to move in longer than 2 or 3 weeks in the first place. They all said they would have no problem doing so and then proceeded to leave to go to the beach. We asked if any had a key. Everyone said no. So we said we would lock the door to make sure the property was secure, since the owners' belongings were still there. Etc., etc. And that as soon as they got back to the house to call us and were across the street, we're able to let them in. When they returned, instead of unlocking the door, Justin and Napur, as well as Rachel Turner, who had not been invited, so it's a typo, to stay overnight at the content house at the same time, and blatantly asked not to be there, broke through a side window on the bottom floor into one of the room a girl was staying in, and then proceeded to vandalize the property, spray painting FRE in the walls. Additionally, several people returned after they moved out, broken and stole some of the owner's belongings. So, this was sent to Taylor Lorenz. This is the truth, outlining everything out that happened. Why did she publish it? Again, all this is showing, this is so damning, is unreal, because all it's showing is she just grabbed this picture, irrespective of The article was published on August 14th. This is August 12th. Irrespective of the truth, she took the picture and put it in an article. I'm sorry, this is damning. Like, how do you come out of this? There's even a report from the police of the vandalism. The fact that Lorenz suggested that Jacob was somehow responsible for the police being called while ignoring the clear evidence to the contrary that was presented to her once again displays defendant's purposeful plan to smear plaintiffs regardless of the truth. Look, listen, if the jury sees this preponderance of evidence, I'm sorry, this case is slammed shut. In my opinion, I'm really interested. Out of the interest of the truth here, I'm really interested to know what Taylor Lorenz had from the other side to make these claims. It must be big. Honestly, it must be. Because you need some sort of a miracle to have this anti-slap stay. From what I'm reading here, this is like Ari is proving her case bit by bit. Defendants then quote Dana Marie, another of the GIV girls who was signed to influences, as claiming that plaintiffs failed to pay utility bills in April 2020, such that the water, Wi-Fi, and electricity went off, and they were using water from the pool to flush the toilets. Defendants further claimed that Jacob had agreed to pay utilities only up to a certain point, and that she was under no obligation to pay bills. These statements are false. The utilities never went off for any reason in April, let alone due to bills being unpaid. Indeed, in March 20, the California Public Utilities Commission, CPUC, instituted a moratorium on disconnections for non-payment of utilities, as seen by the following CPUC press release excerpt. This is what I was talking about. There is no way, I'm sorry, but there is no way you can have that statement still be dismissed after this. Do you not, like, I don't know, can they bring it back? I would, because there's enough here. But anyway, I'm biased, so of course I would do anything because I'm biased, but let me try and put myself in the mind of a judge. If you dismiss a statement and there wasn't enough evidence and you didn't take it under advisement to see this evidence, this is really bad. It's appealable. Moreover, on archive of the CPUC website shows that this information was readily available for Lorenz or fact checkers from the time fact checkers, quote unquote, to consult during the months of April through August 2020. Yet once again, defendants failed to conduct even the most basic fact checking, and instead those choose to recklessly report their false statements about plaintiffs despite the existence of readily available information online to show they were false. They did this to further their preconceived narrative of plaintiffs as abusers of talent who callously subjected the GIV residents to unsanitary conditions during a national pandemic. Okay, so 58. So it says, first, the news has been circulating for weeks before Young and plaintiffs had decided to part ways. And this timing is something defendants could and should have confirmed. Jacob could not have leaked the photographs in retaliation or manipulation because the photographs had already been public weeks earlier. Interesting defense. Second, influences had no business partners at the time to which Jacob could have leaked the photographs. Okay, which is information that was readily available online. That's okay. I see your point. This is just, yeah, fair enough. I mean, yeah. What do you say to that? The fact that Jacob only learned about the photographs well after they had gone public is apparent from the following text message between Jacob and a manager that not collected to influences who alerted Jacob about the photographs' existence and publication. This is so bad. Hey Ari, one this. Ouch. Oh my god. How do you make such an allegation like this? And I'm sorry. How do you pin this? How do you pin this on an Ari? Even worse. Wait, you're. This is so. I'm just. Oh my days. This guy is sent these to 14-year-old girls. You can't be joking. You can't be serious. Let me stop.